Is the Zoom up and running, Heather? Okay. You could have somebody that can give us a thumb. Can everybody hear us? If you could just give us a yay.
Yep.
Yes.
Okay. Thank you. Well, welcome to the public meeting of the Pennsylvania Opioid Trust. The agenda has been posted for the meeting. I would like to make one announcement before we start, which is that this meeting has been duly advertised as a public meeting in accordance with the Sunshine Act, is therefore open to members of the public. Actual participation in the meeting is limited to trustees and to those the trustees have invited in advance to take part. We have invited several different groups, representatives of the AG's office, who are going to explain certain aspects of Wave 2 settlement, representatives from Penn State, who are going to give a detailed presentation of information that we are going to seek from the county. And we will end up taking roll to make sure we have a quorum of the trustees. Heather? Just say aye. You can't see them if they have their thumbs up.
I think it's on now. Chairman Tom Van Kirk,
Present?
Commissioner Kevin Boozle, Commissioner Kevin Boozle, okay, we'll come back to him. Aaron Dalton,
Here.
Secretary Latika Davis-Jones, Commissioner Jean D. Girolamo,
Here.
Representative Jim Gregory, I believe he has a representative attending. Next, Steve Jasper,
Hi, Heather. This is Steve. I'm here.
Shay Madden, Commissioner Robert Postal,
Here.
Senator Greg Rothman,
Here.
and Representative Mark Rozzi,
Here.
Senator Christine Tartaglione. She is not here, but she does have a representative, and Dr. Jean Wright. We'll skip through now. I believe we have 9 in attendance.
I counted 9 as you
Okay.
were going through that, and it only takes 7 for a quorum. So we do have a quorum present, and the meeting can continue, and we can take actions at the meeting. The first order of business is to approve the minutes of the meeting, of the public meeting of May the 18th, 2023. It was all contained in your packet. So any additions or corrections to the minutes of the meeting of May 18th?
Come, this is Steve Jasper. I approve the minutes as presented, or I make the motion to approve the minutes as presented.
Thank you, Steve. May I have a second?
Kevin Boozle.
Second.
Second.
That was by the Secretary Davis Jones. Any further discussion? All in favor, please say aye. Aye.
Aye.
Aye.
Opposed? Okay. Could CCAP give us the financial report?
Yes, if Heather, do you want to bring that up? We did link on the agenda, just a summary of the payments that have been made to the trust and disbursements allocated by the trust to date. other one with the counties. Yes. So you can see, we shared this information, in advance on the agenda, and we have also posted this on our website. This is information, for the payments received by the trust, in 2022, the total of those payments, and then also the allocations that were made to the counties, to the Commonwealth, and to the litigating subdivisions. So that information, is available here. And then we also included the estimated disbursements for 2023 in a separate column. So that information is also included. That information was sent to counties and subdivisions last week.
And was also posted on the website
Yes.
on August the 30th.
So that's all I have for the financial report.
I would also like to report that we did receive a bill from Wilmington Trust for their role in dispersing the money. It was about $16,000. They are charging us, as I referred to, and as we presented at an earlier meeting last year, they charge us $100 per check in making the payments, and it totaled $16,000 for their fee for last year. I'm also happy to say that the trust earned in interest over $1 million, $1,020,000 in interest that was credited to our account, and that money was credited in July of this year. We'll continue to earn money on monies that we have in place. Obviously, we're benefited by the interest rates that have been going up. We did just authorize. We set up a separate account for administrative purposes, and I'm happy to say we're going to be funding that completely out of interest payments. So none of it is coming from the corpus, monies that have been received by way of settlement, and we intend to pay any administrative costs that come from the administrative account. And at least for now, and as long as we're fortunate enough to continue to earn interest as we are, we should have. So we just transferred $300,000 to the administrative account. We anticipate writing out checks from that starting as early as next week. It will be covering legal expenses. It will be covering the payments due under the CCAP expenses, and it will also be covering the Penn State bill when we receive an invoice from them, and we have totally signed off on the contract. So those will be all paid out of that initial $300,000, and likely will cover us for the remainder of payments for this year, and we can discuss at the November meeting additional monies to be transferred from the administrative account. But as I said, to the administrative account, as I said, we still will have approximately $720,000 or so of interest that has been earned that can be transferred into an administrative account. So anybody have any questions as to that very brief but financial report, which covers, I know, a lot of information? Okay, hearing none, we'll move on to the next agenda item, which is the update on the Right to Know Act request that we had discussed at the last meeting. It's one of the reasons that we hired outside counsel, because we had received a number of Right to Know Act requests. We did not think we were subject to it, but it didn't mean that we didn't continue to receive them, as well as a number of counties. So I will ask our attorney, Jack Stover, to report on any update on the Right to Know Act request.
Thanks, Tom. Essentially, as Tom noted, a number of Right to Know Act requests for information and documents were provided or sent to the trust itself. to the administrator of the trust, CCAP, to various counties in Pennsylvania, and also to DDAP, a department of the Commonwealth. The trust denied those requests on the grounds that the right to know law does not apply to the trust. The CCAP also took a denial position as a provider to the trust. The counties generally produced some documentation, but denied other requests that related to documents involving the trust, and DDAP took a position similar to the counties. Because of the denials from the various sources, the requester, Mr. Mahan, who is a reporter, I understand, for Spotlight PA, filed appeals. He filed a series of 9 appeals over roughly a 60-day period. This necessitated responses by the trust in virtually all of those. As a consequence of those filings, major position statements were filed with the Office of Open Records, which is the appropriate administrative procedure in Pennsylvania. On September 1, last Friday, the Office of Open Records, as far as the trust is concerned, essentially made a final determination in favor of the trust, basically determining that the trust is not either a Commonwealth or a local agency under the right to know law, and also determining that as a result of that, the request directed to the trust and the appeals that arose from them is outside the jurisdiction of the Office of Open Records. So that's an excellent result, we think, as far as the trust is concerned, and comports completely with the trust position from the beginning. I will note that there was a second matter that was also decided. Final determination was issued in the appeal that was taken as to Bucks County's denial. So this is sort of representative of the requests that were directed to counties. The OOR determined on Friday that the records of the trust in the possession of the county are not county records. They determined that Commissioner DiGirolamo in that county is not an ex officio officer or ex officio trustee of the trust, and the trust is not an alter ego of the county. They also determined that the records that do not document a business or activity of the county are not records of the county. So these are 3 important findings which restrict requests that can be made directed to individual counties with respect to documents or information relating to the trust. The OOR did direct Bucks County to conduct a further good faith search for any written communications related to the trust that were sent to Commissioner DiGirolamo in his capacity as a county commissioner, not in his capacity as a trustee. So it's a fairly limited category that Bucks County will need to address going forward. Overall, we think these were very satisfactory results, as I said before, completely consistent with the positions taken by the trust from the beginning. I'd be happy to respond to any questions, anybody.
Okay, does any trustee have any questions? Hearing none, we will move on to the next agenda item. I would like to skip because I want to spend a tremendous amount of time on the Pitt, Penn State, and Temple proposal because it does have everything to do with what we're going to expect from the counties as far as letting us know what the money is being spent on so that we can identify it, let the public know what the money was spent on, all of which is in the province of the payees. As you all know, the trust is responsible for, the AG's office is responsible for settling these cases, bringing the money in, if you will, as a result of these settlements. The trust responsibility under the Commonwealth Court order is to disperse that money and to disperse it in accordance with the court order. And that we have done, as you have seen from the financial report. And we have also complied with the September 1st of 2023 deadline to let the counties know what they can anticipate receiving for the remainder of this year. And now we have to move on to the step of having the counties and the subdivisions who are actually spending the money. They are the ones that are making the decisions as to what to spend this money on and how to best help to overcome this opioid epidemic that we are in. So we have to provide a mechanism for them to respond, and in a way that is not a total administrative burden on them, yet gives us enough information to be making our decisions as to whether or not it was money that was properly spent in accordance with Exhibit E and, of course, the Commonwealth court order. So before we get into that trust report, I will turn it over to the AG. By the way, I would note, welcome to everybody from the public that is attending by Zoom. And I would also say that we did open the meeting up for members of the public that wanted to attend in person. And I do see that we do have two people that took us up on that. I'm not sure it quite justifies all the expense for renting all the additional space that we had to undertake, but we do have two people from the public that did decide to attend in person. It must be the heat. With that, Neil, would you like to proceed on behalf of the Attorney General?
Sure. Thanks, Tom. I'm Neil Mara from the Pennsylvania Attorney General's office. I will endeavor to keep these comments brief. As all are aware, there was what we term a wave one of settlements in this opioid litigation. That was 6 opioid manufacturers. Those settlements have provided the funds which have been the trust has been able to distribute to date, and those settlement payments will continue, and the trust will continue to distribute wave one settlement payments. Now, another group of 5 opioid defendants, we have achieved national settlements. They are 2 more opioid manufacturers, Teva and Allergan, and the 3 national pharmacy chains, Walmart, Walgreens, and CVS. So those 5 companies are what we are calling the Wave 2 group. As of yesterday afternoon, all of those 5 companies have reached settlement agreements with plaintiffs in the opioid litigation. Those plaintiffs include the Commonwealth of Pennsylvania and political subdivisions and municipalities within Pennsylvania. But the settlements they've reached are national, coast to coast. So we are reporting on what the opioid trust can anticipate receiving in 2024 as payment proceeds from these wave 2 settling defendants. The top number that the trust can anticipate receiving in 2024 from these wave 2 defendants is $148,086,297.23. It can be broken down. Allergan, one of the settling opioid manufacturers, will provide $11,793,005.91. Teva, another opioid manufacturer, will provide $10,396,000.19. Walmart will provide $94,905,452. Walgreens will provide $16,951,066. And finally, CVS in 2024 will provide $14,040,771.80. The reason we are saying 2024 is because while the parties have agreed to these settlement agreements, the settlement agreements to become fully effective require court approval. So we in the Pennsylvania AG's office will be preparing these settlement agreements for filing with the Commonwealth Court with the appropriate legal procedure and niceties. Plaintiffs around the country will be doing the same. Based on the amount of time that we expect this to take, we don't anticipate Commonwealth Court approval of these 5 settlement agreements before the end of 2023. And that's why these payments we're anticipating in 2024. That is essentially the status of the Wave 2 settlements. The agenda also calls for just a brief update on the status of the Purdue Pharma and Sackler family litigation.
Neil, if I could, before you
sure.
get into that,
Yep.
We, of course, if we're all surprised and the court process can get done this year in time to pay out the money this year from Wave 2 settlement, we will. We are hoping to get the money paid out as quickly as possible. But given the fact that the last time it went to the Commonwealth Court, it took about 6 months for the various settlements to get approved. There's a lot of nuances. A lot of people can weigh in on it. We're just on the safe side anticipating it will come next year. I would also say there's a substantial amount of the 140 million, did you say?
148 million.
148 million coming in anticipated to come in 2024. That is attributable to Walgreen. What is that number?
It's Walmart, and
Walmart.
it's 94,905,000.
And part of that is because their settlement is structured differently. It's not being paid over an 18-year period. It's being paid over an 8-year period. That is a substantial amount of money coming in 1 year and might put a lot of strain. So I would like to, it was suggested at the informational meeting, and I would like to put it in the form of a motion for this meeting that we work with the Attorney General's office to try to build flexibility into the court order so that the Walmart settlement, that settlement, instead of having to be paid out within immediately, can get spread out over several years so that the counties aren't faced with a one-time huge amount and a huge windfall and be expected to spend it and then have that dwindle to substantially less the following year. So could I have a motion that we work with the Attorney General's office to try to build that flexibility into that particular payment?
Hey, Tom, Gene DiGirolamo, can I ask a question, please?
Yes.
Okay, this is for Neil. Neil, I am absolutely adamantly opposed to any type of criminal immunity to these entities that are making settlements. Is there any language in these Wave 2 settlements that grants these entities any kind of criminal immunity?
There is not.
Okay. And just to follow up when you get on the Purdue Pharma, because I know the Sackler family is desperately trying to get themselves criminal immunity. Would you please address that when you get to the Purdue Pharma settlement as well, if the criminal immunity is in those settlements for Purdue Pharma and the Sackler family?
Sure, I'd be happy to. Should I move on?
No, let's,
Okay.
yeah, I'd
Yeah.
like to vote on this if we could. So could
Tom,
I have
I'd like to make the motion that we get the flexibility to the trust in the order from the AG's office. I think it's going to be necessary to smooth off some of the payment options, and I think the trust is going to need that flexibility. So I'll make that motion.
I'll second it.
Right. Any discussion on the motion? All in favor, please say aye.
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 Opposed? Okay, motion passes, and we will work, Jim, with you on that. Gene, you must have been reading the same books over the summer that I was. If you read The Empire of Pain, which has to do with the whole history of the Sackler family, it's hard to walk away from reading that book and not be fully in accord with letting anybody off of criminal liability, because the book makes a very persuasive cases that many of the opioid manufacturers particularly, and the Sackler family in particular, uh, bear a great responsibility for what they convince the public of on this. But you can address that in your own way. That's my own personal opinion.
Todd, in my mind, and I've been fighting this epidemic for years. If they get away with this and are not criminally prosecuted, it would just be a disgrace for the whole thing. They are desperately trying to get out of this, and they want the criminal immunity as part the Sackler family and even the other entities as well. I mean, I am going to fight that with every bone in my body if they try to get away with that.
Thank you, Gene. Neil, would you like to address it?
Sure. And I just want to note again to emphasize, we've indicated anticipated amounts from the Wave 2 settlements, but it really is contingent upon court approval of the settlements. So we don't anticipate problems obtaining court approval, but the court approval is the triggering mechanism to allow those payment to allow the process of those payments to move forward. As far as the Purdue Pharma Sackler status, as many know who've been following it in the press, the case has been accepted by the United States Supreme Court. They will consider it. There is a briefing schedule for the parties for this fall. In fact, initial briefing is coming up at the end of this month, and then there'll be follow-up briefing at the end of October. There will be oral argument, and then that case will sit for as long as it needs to sit before the Supreme Court for them to consider it and issue a ruling. The impact of that is it does not involve criminal liability in any way. The matter on appeal that the Supreme Court is considering in a simplified version is that Purdue Pharma as a company declared bankruptcy. The Sackler family, individuals in the Sackler family, did not. They did not declare bankruptcy. Within the consideration of the Purdue Pharma bankruptcy by the bankruptcy court, the Sackler family offered to greatly enhance the value of the settlement in the bankruptcy procedure if in return they received releases from civil liability, not criminal. So they are a non-bankrupt party getting a benefit from the bankruptcy court. That is the issue. The lower courts have decided, it's gone back and forth on lower court appeal, and now that issue is before the United States Supreme Court. Can a non-bankrupt third party obtain releases from civil liability from a bankruptcy court? So that's what's pending. In the meantime, the settlement that was worked out very, very diligently and over a long period of time in the bankruptcy process is on the shelf. There will be no proceeds distributed from the Purdue Pharma settlement until the United States Supreme Court rules. They could rule if they rule one way, the settlement can proceed. If they rule another way, then everyone is back to square one. So we wait is the bottom line for Purdue Pharma and the Sacklers. Mallinckrodt, if I'm looking at the agenda, Mallinckrodt is another opioid manufacturer. It too declared bankruptcy. So it is not even part of the Wave 1 settlement group, but agreements were reached in the Mallinckrodt bankruptcy that they would pay certain amounts to opioid plaintiffs like the Commonwealth of Pennsylvania, the subdivisions, the municipalities. Interestingly, The Commonwealth of Pennsylvania and its subdivisions anticipated receiving approximately $49 million under the terms of the agreement that was reached in bankruptcy court with Mallinckrodt. In subsequent months, things have turned against Mallinckrodt. Company performance is not what was anticipated, so they have declared bankruptcy again. So now the trust can anticipate receiving approximately $7 million more from Mallinckrodt, and then that would close that out. So bad fortune for the company, bad fortune for us, but that's what we anticipate the Mallinckrodt proceeds to be.
Question, Tom?
Yes.
Yes. Neil, as part of the Purdue Pharma and the Mallinckrodt settlement, were any part of the proceeds that they are going to pay be paid for with MAT, which are Medicaid assisted treatments, like Suboxone or any of the other MATs?
No, that wasn't part.
There was one point in time, I think they were trying to say they were going to manufacture these MATs and make that part of the settlement, but that is not in any of the settlement, especially with Purdue Pharma?
That's correct.
Okay, thank you.
Okay, any other questions? I would note that with this bankruptcy, second bankruptcy of Mallinckrodt, did have a question as to whether that would affect the money they already paid, approximately $7 million, which they paid in February. I've been assured that it doesn't affect that, so we have included that $7 million payment in the money to be distributed by the end of the year. And it was part of the posting that we made for the and the material that went out to the counties as to monies that they could expect to get. We do anticipate that it could have an effect on any future money, so we don't take an opinion on that, but anytime it gets thrown into bankruptcy, who knows? Now, fortunately, the overall amount was going to be a relatively minor amount compared to the entire amount Pennsylvania was getting, but still, it's probably going to be a loss of 42 million over a 10-year period of time or so that we're going to miss out on. So, yeah, but that will all be within the AG's hands. With that, I'd like to move on to what I really hope is the main part of this meeting, because I know the counties are going to be very interested in what information we're going to be seeking. So you know, it is a fairly detailed presentation. There's been a lot of different reviews of this, but it's going to have to be reviewed even further. We do want to make this user-friendly if we can. We do want to put the onus on the counties to the extent we can to identify why they believe the money that they expended falls within Exhibit E. So I think it's important for this group to see exactly what we're proposing to go out with the county. As Dennis will describe to you, we do anticipate that if this group approves going forward with this particular format, we're going to do test drive it with a couple of interested counties coming up in the near future to make sure that in practice it works out, and that they will be able to work with this and also get additional comment before the counties are required to fill it out. That doesn't mean we won't be rolling it out to the counties so that they can anticipate the questions that we're going to be asking. So, Dennis, if you would take it from here.
Is that microphone on? I think it was off. Okay. So Dennis Scanlon from Penn State University, colleague Glenn Sterner is here as well. I do want to note that even though you see the Penn State logo, as the trust had requested, the development of this has been in partnership with colleagues at both Temple and the University of Pittsburgh. So we've put our collective research minds and experience in this area together to try to develop this tool. What I'm going to do is preview this today, but I think it's important to start with the purpose of the data collection tool. And, I think the purpose is really the following. First of all, standardized approach for counties and sub entities to report details about how they have spent and plan to spend settlement funds received. And as Tom had mentioned, that's really a requirement of the settlement. Specifically, there needs to be spending in accordance with what is allowed under Exhibit E and its two schedules A and B. And so the tool has been built to incorporate those dimensions, which are quite specific, so that those receiving funds and spending funds will have to report how what they're spending on accords with those requirements. As was also mentioned, the goal is to make this a least burdensome exercise. So the information is important, but we understand that those in the trenches have lots of important work to do and don't need to be sitting around and doing more administrative work. So we tried to make sure that we can limit that burden as well. The trustees itself and the trust requires data and summary information to fulfill its various responsibilities. I think, again, as Tom said, not the least of which is to make sure that the spending is in accordance with Exhibit E, Schedules A, and Schedule B. But as also mentioned, there's a variety of others interested in this information, and the information can have impactful purposes, sharing of information around how monies are being spent, what the impact of that is, who one is contracting with, and whether they're doing a good job and delivering what they say they're deliver for contracted funds. Tom, did you?
I just have one thing under the second bullet point, and as we discussed in the previous meeting, this really is not needed to fulfill our fiduciary responsibilities. It is not a fiduciary responsibility. It is an obligation placed upon the trust by the Commonwealth Court in order to comply with its order. So that is the reason that we are receiving the information that we need in order to perform our duties under the court order.
Yep. And a lot of partners, I'd say CCAP, PACTA, DDAP, and others that certainly are interested in this, in addition to the public. And as was mentioned earlier as well, and this will be at the will of the trust, some interest in figuring out a way to take this information, package it in a way that can be most useful so that stakeholders in the Commonwealth have an understanding of both how the monies are being spent, but ultimately, and this is the last point, what its impact is on public health. Just to drive home that point, a couple screenshots, you can find many of these, but the idea that there really is a demand for accountability of how these funds are being used. And so this tool should allow the trust the ability to do that. A little bit of just specifics on the tool itself and how it was developed. We're using a platform called RedCap that has a lot of advantages from a data security perspective. It's used very commonly in academic medical care related research. None of this is HIPAA related because there's no patient specific information of what's being requested here. But the same principles from a security perspective make sense. It also allows for longitudinal data collection, and given that the payouts are going to be happening and the spending is going to be happening over a multi-year period, money's coming in, money's going out, expectations about the timing when that money needs to go out the door so that it's just not sitting there. This has a longitudinal component to it, which will allow for this to be tracked over time. Another way to really think about it is after the first report, subsequent reports are really just an update to the initial report. It's an update based on spending that occurred in those periods and monies that came in that interim period. And I'll get into an example and some timelines in a moment. To make sure that those who are required to report, counties and any municipalities or other entities, we will be available for technical assistance and support. That'll be really important up front to do some initial training and make sure that everyone that has to report understands how to use the tool. We'll also record that training so it will be available in perpetuity. And then we will maintain a frequently asked question list, which we will update. To be clear, these questions are related to reporting obligation in the tool, not other questions that might come into the trust, which would relate to, is a certain expenditure allowed relative to the to the settlement agreement. And so let me kind of get to it and go through an example. So what I'm going to show here are some screenshots from this online tool that will be accessed via secure link. So if you are a county, a reporting entity, you will a couple months before the date when the report is due, receive a link which will take you to information requiring you to report. What I'm showing here actually is something that the reporting entities won't see. This will be pre-populated by what we call study personnel or our staff. But I want to show this because, you know, factually, we will know the information as I think was presented at one point. The reporting period start date, the actual amount of money that was dispersed, and the county subdivision name. So in number 3 there was a drop-down menu which has every county in the Commonwealth and also any other relevant subdivisions. For purposes of the example today, I'm going to select Test County, which we've added, just so that this becomes a hypothetical or example, but one that is real. So this will allow for, over the course of, 15 or 18 years, every time there's a disbursement, we will have a date of the disbursement, we will have an amount that will be pre-populated, and that will aggregate up into an ongoing total that will be the subject of reporting as we'll see in the next link. You have a question?
Not really a question. I did want you to know, though, that even though it says up there, the county subdivision, we have discovered in going through this that under the current court order, litigating subdivisions, those that are participating in the 15% of the pot, are not required to send in information regarding how the money was being spent. It only applies currently to the 70% of money that the counties receive. We are, however, in the next settlement, going to attempt to amend the order because we think it's appropriate that everybody who receives money from the trust has to file and set forth this information. That's why the tool is currently setting forth subdivisions as well as counties.
Is this a time to address in the reporting the issue of if a county makes a payment to a subdivision, the county's reporting obligation for that?
I think you cover that further in this.
Right.
So we can do it there.
Okay. So again, that will be populated based on the facts of how much has been dispersed and at what period of time. The link that will be received will go to, in this case, Test County, as you can see. The reporting period covered for the initial report is going to be from August 1st, 2022 to December 31st, 2023. So in the interest of time, so I'm not entering this live, I've gone in and created this example. Subsequent reporting periods, as we'll show, will cover different periods of time. There will be the drop-down menu, or quite frankly, for our test case, we have all the counties listed. The link will take, if I am in Test County, I will only have the option of seeing Test County because that is what I'm reporting on. And the dollar amount that you see there, no commas, that's a feature of this data entry tool, but I believe this is roughly 1.4 million, a little bit shy of that with some change, would be amounts that would be pre-populated in what was dispersed and should have been received in this reporting period for Test County. We then get into the questions around, did you spend it and what did you spend it on? So the next question is, what is the total amount of settlement funds remaining from the previous reporting period? In this case, that's going to be 0 in all cases because there was not a previous reporting period. This is the first reporting period. But as I'll say counties or other reporting entities go forward, there may be monies that may be a non-zero amount if they had not spent the entire amount of money received in prior disbursements. And so this will basically be longitudinal in nature and track that based on responses. The next question, what is the total amount from funds for purposes that qualify as opioid remediation during the reporting period? So we created an example here that said 500,000. So even though they received 1.35 million, they have spent to date or 500,000 in terms of opioid remediation. That and in my example, this is a streamlined. Why this isn't advancing? Yeah, I need to admit. Okay. There we go. This is different screenshots put on different slides, but this is one seamless, continuous thing. If you're filling this out from the link online. Another question, and this was discussed recently, Tom, I don't know if you want to say anything related to this, but we were requested to add whether the reporting entity is requesting a 6-month extension beyond the required 18 months to spend settlement funds received. And so we have a yes or no. Anything you wanted to add on that? Okay. I'm going to skip this next question because actually I think we have a wording issue that I discovered this morning, but let me move on. Importantly, for the amounts that are listed as spending, we're going to ask a level of detail. So basically, what remediation program or strategies did what did you engage in, and specifically, what did you spend money on, and how do those comport with what is allowed in Exhibit E and Schedules A and Schedule B? And for those familiar with this, Schedule A and B are all part of Exhibit E, but Schedule A calls out a certain list of activities, but everything in those schedules are all part of Exhibit E. We asked the name of the person completing the survey, the email address of the individual completing the survey, the phone number, and we do that just so we can follow up with anybody if there are questions, if there are concerns about what's reported, if we see any errors or mistakes, anything of that nature. But then we get into the specific remediation program strategy. In this case, we've created an entry that's called Test County Jail System Vivitrol Program. The name of the organization managing that remediation program strategy would be Test County Jail. So this could be pick your county, Berks, Allegheny, whatever the case may be. I'm using the term Test County here. We have the name of the individual who's managing that particular program strategy. So the $500,000 entry that we saw is related to this particular this particular example, and you can see the $500,000 listed here below. It was requested that we make sure we have a linkable copy of Schedule A and B in the, we need to go back one, Glenn, in the tool. And so there's a PDF that one can click on if the responder wants to see the full details, which is part of the settlement agreement. For this particular program, again, the County Jail Vivitrol Program, we ask whether they're reporting this using Schedule A or B. In this case, Schedule A is chosen. Regardless of which chosen, it then generates a drop-down box. In the items that you see here, A through I, are items, again, part of that Exhibit E in Schedule A that are part of Schedule A. So when Schedule A is selected, there's a drop-down checkbox, and the question says, which of these under Schedule A most closely describes the remediation program that you're reporting on? And so in this case, we've checked B and F. B, which is medication-assisted treatment, distribution and other opioid-related treatment, and F, treatment for an incarcerated population. You can check as many or up to 3 that apply. And all of these are verbatim taken from both Exhibit E and Schedule A and Schedule B. Moving on, the next question, select the specific Exhibit E approved remediation. Here, the choice is increased distribution of medication-assisted therapy to individuals who are uninsured or whose insurance does not cover the needed service. We then ask this next question in the checkbox here is increased funding for jails to provide treatment to inmates with opioid use disorder. We then want to know whether this remediation program is fully funded by settlement funds, or it may perhaps be jointly funded through other state, federal, or other funding. And so here I've checked the box no, meaning that this is funded from other sources as well. We ask what sources of funding are being used. The drop-down box would have federal, state, and some other options. I've selected state in this case. We then ask whether this remediation program effort is still active. I've selected yes. And we ask whether this effort has a dual role. For example, does it target treating opioid use, treatment of a mental health diagnosis? I see a hand up here.
You know, if I could just say, one of the, where it says what other sources of funding are being used, you note that in some of the questions that were asked of us, we responded that you could only use properly the money that is coming from the opioid trust for a certain percentage of the use. For example, I think on body scanners, we said that yes, body scanners to keep drugs from getting into jails may well be a proper use, but to the extent that you are also using it for numerous other purposes, which is to keep drugs out, to keep guards from bringing it in, etc., that you can only spend a certain percentage. What we're trying to ascertain here is what other sources of funding are being used, with the hopes that a lot of that funding will be other monies from the county, not from necessarily identifying specific state funds or anything else, because the counties do owe certain obligations to do things over and above money that they're receiving from the trust.
And I think another example of that, Tom, would be, you know, there are a variety of federal or other programs that could be matching funds or other sources, grant funds that could be used, right? So that would be another example where it's cobbling together different resources that can be used for a single purpose. And so that leads to the bottom question, which is, if this is a dual role program, what percentage of the funds for the program are being used by the opioid settlement funds specifically? We go on to the next questions. You know, we provide an opportunity for notes or comments about this program or strategy. As you can see, I've just centered here that there's any additional clarification or element that one wants to add, they can. And now that I'm thinking about this, I think you know, one suggestion that I think we may want to make is the option to attach a document if somebody wants to say, you know, here's some detail on a voluntary basis. We certainly think that would provide that would be a good addition. Does your county or subdivision have an additional remediation program strategy to report? So in this case, I've selected no, just for purposes of the example, but we know that it won't be a one and done. The funds will be used for multiple purposes. So when one selects yes here, it would take the respondent back through the same a tool to state the name of the program, state the purpose of the program, how it fits Schedule E in Exhibits A and B, and so forth and so on. And so it would be a complete accounting, would be the expectation of any funds expended that were received from the settlement. We know that funds don't get spent as soon as they come in, obviously. It takes planning, it takes strategy, it takes RFPs and contracting and so forth and so on. And so, you know, funds will not have been spent, but some of those funds may have been allocated or committed for ideas that the reporting entity will know about. So we asked under future plans.
Dennis, I'm sorry. Kevin, do you have a question?
I do, and I don't want to interject too soon. I appreciate you pausing for a second. One of my questions that I think we're going to have at the end of the day is, as I'm watching you fill this form out, we do have some one-time costs, like some upfront costs, whether it's purchase of a capital building for a resource center or whatever the case may be. And if it's a one-time cost up front, is there a way to report that so that they're not, because I'm assuming that this, when I go to fill out my second report, some of this information would be pre-populated, and I wouldn't want to keep reporting on something that was a one-time effort. Do you follow where I'm going with that?
Yeah, and I think I'll go back. I will have to think about whether I want to say that this would address your comment, but on the fly here, I want to give that more thought. Notice a question here that says, is the remediation effort still active, yes or no? We would intend, based on that yes, to, as you said, pre-populate the next time and not have all the information entered again, but to have an update of that information in the next reporting. If it was a one-time only, I guess the phrasing here may not fully fit. As you said, it may be a one-time as opposed to a remediation effort. So I conceptually, I understand what you're asking, Commissioner. I think we need to think a little bit more about that. Because I guess the question would that still, the example that you're using, would that still constitute a remediation activity that would fit under Exhibit E?
Yes.
Then I think maybe active is not the right term, because that one-time expenditure is, the terminology active may not. So I think we need to give some more thought to that. But
Yeah, and I'd love to be a part of that team that reviews, because one of the things that we did in our program request is startup costs, operational costs, annual estimated operational costs. So we broke it down a little bit per program already by people making these requests, but I think this is something we can get into later. I don't want to take up any more of the time for this presentation, but happy to talk to you offline. Thank you.
That gives you one volunteer county. to test it
Exactly.
with.
no, appreciate that. That's exactly.
There's one down and one to go.
That's the feedback that we need. So we will take you up on that. Thank you. The future plans is fairly similar in terms of questions. The first question is just, are there future plans or ideas that have not been launched to date? Yes. What is the budgeted cost of those future remediation program strategies? This is again, where we may want to tweak the wording a little bit, because, I assume there's always future plans. We may want to clarify that these are future plans that are concrete enough that you've got names and dollar amounts, right? But this idea here, for purposes of the example, we put again another $500,000, $500,000 in here. And again, if it's concrete enough, it should conform to Schedule A and Schedule B. I've said yes, and I've selected, in this case, Schedule B. That triggers an additional or a different drop-down menu relative to Schedule B. And here I've selected G, prevent misuse of opioids, and 3, public education relating to drug disposal. By the way, I think that's 50,000, not 500,000. Sorry. And then this is a program that would involve public education related to drug disposal. After that, once again, there's the opportunity to add additional entries if there are other future plans, and then to submit. What I will say is, for purposes of filling this out, the tool allows for the respondent, if you can see, I'll go back, to save and return later, or to just submit. But if one wants to work on this and over multiple settings, that can be done. So additional information can be gathered. If you save and return, there will be a return code for the respondent, and they will get an email with a link so that they can go back and update or change or tweak their responses up until the date when the reporting is complete.
Right.
I have a little information about timeline, but I wonder.
To reiterate, by the way, this information will have to be filed for each of the opioid remediation programs, so that a smaller county may only have 1 or 2 and have to go through. Philadelphia, Allegheny County could have 50 or 60 that they are going to have to go through, but it is meant for all of this information to be supplied as to each of the remediation programs that are being used.
Do you want to take any, before we talk about timeline, do you want to take any other questions on content at this point?
Anybody have any other questions about content? Okay, go ahead.
So, hearing none, if we think about building this out, we've gone through several iterations already. I think we have a suggestion or 2 here that we want to make some changes to. Wanted to get this feedback at this public meeting and the meeting of the trust. We want to do, and I think Commissioner Boozle will take you up on your offer, and have about 2 counties, sort of help us to think about this from their own perspective, just to make sure, as Commissioner Boozle suggested, that there aren't some things that we haven't thought of, and we can incorporate those in. At that point, we'll make what we hope will be the final technical modifications, but certainly we can make those further. And then we would proceed to live trainings for reporting entities with the goal of hosting 2 live sessions via webinar, similar to this, a little bit more detail, where we would do that by mid-October. We would record one of those so that that would be available for anyone that missed, or if there's a staff change, somebody else is going to report in the future who didn't report previously. And we would compile frequently asked questions as they come in. Once again, these frequently asked questions would be relative to the reporting obligation in the tool, as opposed to questions that are more appropriately routed to the trust. We then would proceed to the proposed timeline in the initial reporting period, which is very much driven by my understanding of the terms of the settlement agreement, but also for purposes of allowing the trust to get the information it needs and also to get that information out into the public. So in this first reporting link, we would send in November of 2023 the URL, essentially the link to each county, which would have that related information that I that point would be everything paid as of November. We know that the trust is to send a payment, I think December 15th, approximately, and so the reporting period, since it goes through the end of December, will need to include that payment. Those monies may not be spent as soon as they come in, but it should be accounted for in that reporting link. So we will send a updated link right after that, December 16th or so. That shouldn't be a problem because, again, using that save function, counties can go in and start to enter their information and then just update it. But the final submission that we're proposing of the data for this first reporting period would be February 15th. We would then proceed within that next month to provide, as Tom had mentioned earlier, the trust with information around the uses of the dollars in terms of expenditures and how they fit Exhibit E, Schedule A, Schedule B. Any expenditures that did not fit that, we would flag for the trust. And then we would start to work on what we'll call a more detailed report, which would get into a lot, whatever level of granularity the trust would want around types of programs, populations covered. Really, that would be dollar amounts and elements of Exhibit E and Schedule A and Schedule B. And then finally, for the future data reporting, as I mentioned, first data reporting is going to cover more than a 12-month period by virtue of where things stand at this point. But the idea would be to have this reported by a county or a eventually subdivision. I want to note that we actually believe, and I think this is a decision for the trust to make, but we actually believe that twice per year reporting will be easier because the information is largely an update. Again, it will be longitudinal. A lot of the entries that are still ongoing will be pre-populated. The dollar amounts will change. So in some sense, as an accounting exercise, doing this roughly twice a year, we think will help to reduce the burden, but that's a trust decision. The time frame covered then that we would propose would be January 1st to June 30th in reporting period 2, and that would be for calendar year 2024. And then the third reporting period would be July through December, and we would recommend that cadence continue through the life of the settlement. Once that time frame enters, we'd give about a 2-month period for the county to report, and then we would work to quickly turn that information back to the trust.
Yeah, I do want to reiterate, we're not making the decision today to have this twice a year reporting. We are going to have further discussion of that, but it's not a decision we have to make right now. What we do have to make is the decision is to move ahead with this kind of format so that we can start rolling it out, get it out to the county, start making decisions. So if I'd like for Dennis to entertain any other questions you might have about the reporting requirements generally, the format we're intending to use, but not hearing, if we don't have any further comments, I would like to have a motion that we will proceed with this format with the next, events being to test drive this. It doesn't have to be with just 2 counties. It can be with 2 or 3. And then also aim for no later than the end of October to have these training sessions. We're currently, as Dennis mentioned, planning on having a couple of them, recording one of them, so it'll be available, but we're not limited to just having 2. We will have as many as is necessary so that the counties have a full explanation. And we will work with our friends at, CCAP to make sure that, that they coordinate with the counties to make sure the counties are fully aware of their ability to participate in these, training sessions. So, is there any further discussion of the materials that Dennis discussed? Hearing none, could I have a motion that we proceed with this format, recognizing that if it has to be tweaked, we will tweak it, and we're not giving the final say so, but we're going to proceed on this basis and see what develops from the test runs and with the training sessions. But that's not to say I expect that there'll be a wide deviation from what we are recommending going forward with today. So could I have a motion to that effect?
This is Commissioner Post, so I'll make that motion, Mr. Chairman.
Thank you very much. Is there a second?
I'll second it.
Okay. Any further discussion? And by the way, I apologize. I'm going to take the vote, and by matter of habit, I usually say aye. I don't have a vote unless there's a tie, so just disregard my aye for this. Could everybody in favor of the motion, please say aye.
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 Any opposed? Motion passes. Okay, thank you very much, Dennis. Okay, the next item on the agenda, it's stated as a review, but you all would have received. We did post the estimate of disbursements to the counties and subdivisions. It was all sent out to the counties on August the 30th. It was posted on the website. You all received it in the in all of your packets of information. So as we said, it is an estimate. There could be further changes depending upon, and there were last year, by the way, from what we initially sent out, as it comes out with what is actually paid in and what other expenses.
I think we lost audio.
Can you get any of the participants on the screen?
We can hear you now.
Can you hear me?
Yes, and we can see the meeting room.
Thank you. I really apologize for the inconvenience. Nobody's fault, but a little bit of equipment failure. So I think we were right in the middle of the resolution that is on the screen right now. It is merely a change. Now that we have set up the administrative account, it is to substitute Heather for the person that can sign on behalf of the of CCAP as our administrator. It is my intention that most of the checks that get paid out of this administrative account are going to be paid by CCAP, and that is with the exception of checks that are being sent, being paid to them, in which case I will be the signatory. So could I have a motion to adopt the resolution that is on the screen in front of you?
So moved, it's postal.
Second,
Second, Boozle.
any discussion? All in favor, please say aye.
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 Thank you. We now have the approval of the process for counties and subdivisions requesting an extension for funding allocations. There is the provision that was also in the materials submitted to you prior to the meeting. The most important part of this, which we've labeled as the standard operating procedure, is to state that people can at all times request an extension, but to make it clear that for the first reporting period, if they request an extension, it will be automatic. For a 6-month extension, it will automatically be granted, even though they still have to request it. So could I have a motion to make the extension period automatically extended for this first period, and thereafter they will have to seek approval to request an extension or to receive an extension?
I'll make that motion. Kevin Boozle.
Thank you, Kevin. A second?
You have a second by postal.
Thank you very much. Any discussion? All those in favor, please say aye.
Aye.
Opposed? Okay. The second standard operating procedure is a little bit more complex. As you know, we set up the technical advisory committee in order to help aid the counties in making decisions as to whether or not their contemplated uses for opioid abatement funds passes muster, would be approved. And the technical committee has met, and we issued and we discussed at the last meeting, and it was contained in the board packets, various authorizations, and we did get back to the counties based upon everybody being affirmative. At the same time, we've had a second group, which we are going to discuss in a bit. But the technical advisory group just is not confident with us four being the only people that weigh into this. We really want to have a procedure for having all trustees see what advice we're intending to get. At the same time, we don't want to have to call a meeting once a month in order to do it, particularly when this issue basically goes away at the end of this year. Because people will be getting the formal responses at the end of this year and know whether things are being authorized. So we're trying to reach a way in which we comply with the Sunshine Act, but at the same time we give all of the trustees an opportunity to weigh in and say whether or not they agree with what would be proposed by the 4-person technical advisory committee group, which, by the way, has been meeting every other week on Thursday morning. We meet and discuss what the requests are and do some research into them. And there is a whole group that we have proposed for this meeting that have been submitted to all of you. We did ask for comments about those. We only received one set of comments, and nothing from anybody else. We did say in that notice that that unless people had objections to it, that we would proceed to get back to the people who asked the question with the advice that we proposed. And I just want to formalize that that is a procedure that you all are comfortable with, that that we in fact will send out what our draft responses are. And the board shall have 5 days to respond to the trust administrator if they're in favor. And if nobody receives it, we will take it that we have the approval to send it out. Now, all of this, by the way, is subject to what we are going to be telling anybody we give advice to. And I am going to read this because I do think that that it's done in such a way that it doesn't completely bind us, even though we're giving. And remember, we're not required by the Commonwealth Court Order to give this information. We could just sit on our hands, let the counties do as they want. But I do think we're well advised to give them guidance if they want it, particularly if we want them spending money as quickly as possible. So with regard to any advice we give, we propose to say that the Board of Trustees is not specifically authorized to provide advance input to recipients of distributions of trust funds with respect to a proposed use of funds, other than to advise that the only uses listed on Exhibit E to the settlement agreements and available on the trust website are authorized by the settlement agreements and the Commonwealth Court Order, recognizing that the recipients may need some level of guidance on such authorized uses, and in an effort to maximize appropriate use of funds in compliance with the settlement agreement, the technical advisory group providing this response is responding to this. Such responses should be considered informational in nature and should not considered to be deliberations, the results of deliberations, or any official action of the Board of Trustees or the technical advisory group. So we do put those stipulations in. We're trying to provide some guidance, but we do want all trustees to say, hey, look, I see what you're proposing to say to them. I just think it's dead wrong. But as I said, this last set that we sent out, there was only one comment, one person who commented. Otherwise, people were satisfied, I'm believing, with what was set forth. Because we did have this meeting coming up, I did want to get the operating procedure passed in order to go forward with this, but didn't want to automatically send out our responses based upon the fact that 10 of the 11 trustees, excuse me, 8 of the 9 trustees who aren't on the technical advisory group didn't indicate any disagreement with it. So I think as the first order, I would like to ask if anybody would be willing to make a motion adopting the standard operating procedure that we will, as set forth in everything that was supplied to you, that the technical advisory group will send out what its proposed responses are to the members of the Board of Trustees and give them an opportunity to comment on it. And assuming they have no comments and that we have a concurrence, that we can send it out all with the cautionary language that I just read to you. So could I have a motion to that effect?
I'll make the motion for the SOP, column, Kevin Boozle.
Thank you, Kevin. Any second? We'll take a second. Okay, any discussion?
Just suggest, Mr. Chairman, this is Commissioner Postal. I think, I don't have it here in front of me. I think it says 5 business days that turnaround, or it doesn't say 5 business days, it says 5 days. I could live with 5 days. Um, 5 business days would make it, I've seen that more appropriate. But, if it's a problem, it's fine. But right there is where I think I've seen it. The members of the advisory group shall have 5 days to respond. You want 5 business days. And then maybe further on, when you get a response from the trustee, I think has 5 days too. Am I correct? Again, I don't have the text in front of me.
Yep.
Yeah, if the response is not received from a member within the 5-day period, I would say 5 business days just because of weekends. I'm not sure how the schedule is going to go.
Okay, Kevin,
It's a
Kevin,
suggestion.
as the person who proposed this amendment, you accept the amendment, proposed by
Postal.
Postal to do this, to make that amendment?
I do,
5?
absolutely. Yes.
It's acceptable, so, we have a motion and a second with it being amended, to 5 business days. If, having a motion and a second, any further discussion?
Just for clarity, if I may, Mr. Chair.
Yes.
I know I helped design some of this, but I can't remember and I can't seem to locate it. Maybe it's here. So if there's no response, or if there's a response about a particular question that we've received and the response that we're giving, is it possible to pull that out for the full board discussion and allow the others to go? And that's one question. And the second question that I would have is, do we formally adopt the responses at each board meeting, just a matter of record?
I am proposing for this meeting to adopt the responses, since we do have a voting meeting. The primary reason for this standard operating procedure is so we don't have to let 2 and 3 months lag before we get back to people. So
And to my first question would, can we pull it out, like pull one out before we do a formal response?
Well, that's the reason. I think the procedure is that after we get responses from the trustees, it goes back to the technical advisory group to make the decision whether they want to go forward or want to pull any or reconsider what their advice was.
Thank you. That's clear enough for me. I'm good with that. Thank you.
Okay, thank you. Okay, any other questions? Yes, ma'am. No, all I'm asking for this is the motion going forward, and we are going to have a full discussion of the ones that were sent out and that the senator commented on. Okay. Okay. Yep. No problem. Any other questions? Okay. Could we have a vote? All in favor, please say aye.
Aye.
Opposed? Motion passes. Okay. With that, I think we can move on to what the proposed responses were. All of that is in your meeting material. And Morgan and Senator Rothman, if it's okay with you, because the comments that we received were from the senator, I will let him propose what it is. But I did send it out to the group. Did not receive any responses, and some of them weren't just tweaks on the actual advice being given, but some very good things, which if you don't mind, I will respond to. The senator did want to know where the previous trust advisory, group answers are posted. They are not posted. They were in the meeting materials. They are part of the, materials that were sent out. And it would be our proposal to do all previous responses along with whatever is agreed to today, okay? And that will all end up being, actually being sent out to the, it's always available to the trustees, but we are going to be sending it out to the people that pose the question. A very legitimate question. Questions for this round were submitted as early as July 2nd. 2 months is a long time to wait before getting a response from the trust. What efforts are going on behind the scenes to improve this process? It's not even behind the scenes. We're adopting the standard operating procedure in order to be able to speed up the process. And it's a point well taken. All I can tell you is that we received them. As I said, we've been meeting every other week. There were some vacations that interfered, but we were getting to them as quickly as possible. But by the time it got to when we were having a final determination about 3 weeks before this meeting, we thought, let's just wait and discuss them at the meeting for people that had questions. I believe, okay. Another question asked was a question regarding the Clearfield County body scanner. Asked if we could expend upon the general recommendation that equipment purchases are limited to no more than 50% of the funds received. Where does this recommendation come from? Is it 50% of the total funds received or anticipated? Actually, it is 50% of the total funds that have been received, and we think that it is a very rare equipment purchase or anything else that goes 100% for opioid remediation, as opposed to a lot of other remediations that may be going on. And we just thought, as a rule of thumb, we would point out that we don't think anything more than 50%. But obviously, if a county wants to go further, say, hey, wait a minute, no, we need it 100%, and here's the reasons why, we certainly could reconsider it. But that was for general advice purposes. There was a question regarding the Elk County request, and it appeared as if the board will accept the use of funds for a school resource officer. Further said, although I believe the use of these funds for hiring additional law enforcement was previously denied, could I explain the difference between that denial and this approval? It was the thought of the committee. And by the way, Latika, Kevin, Shay, I don't want to dominate this. Weigh in, please, on any of it. You're all part of the advisory committee and can discuss it. But it was our belief that a school resource officer goes far and above being, it is not a police officer. It is somebody to provide information to students, all aimed at providing information and education to try to keep opioids from being used by school students, and wasn't really meant as a police officer. It's obviously correct that previous advice that we had given concerning law enforcement is absolutely correct. We do not believe that these funds ought to be expended, nor was it authorized by Exhibit E to hire additional policemen to put out and police the streets and try to keep drugs off it. That's a separate county responsibility and not part of an opioid remediation. We think we've made that clear. I know certain counties disagree with that. They have the right to appeal it if they want to, but it was not the purpose of these funds to go out and spend money to put additional police on the street. That's an otherwise responsibility of the county. There was a question that as far as who decided the makeup of the trust board, and they thought we had to give a bigger description. I happen to agree with that, and it will be, as suggested by the senator, that it was directed by the Commonwealth Court order of July 15th. That's how the makeup was, and they go into quite a bit of detail about the qualifications for people to be made to serve. Excuse me. question about the timeframes for reporting and fund usage will be linked to fund distribution, not fiscal years. That's correct. And I think that was being addressed in the material that we went over with Penn State. Regarding the question as to why defibrillators are not an allowable expense under harm reduction, it was our belief, and I would stand to be corrected on this as being aware of the defibrillator, as a matter of fact. I don't think defibrillators are generally thought of as an opioid remediation effort. Naloxone, the drugs, the various things that first responders use, but it was our opinion that this wasn't something, at least in our opinion, that the defibrillator advices are used for opioid remediation or to help people recover from that as much as some of the other things that are more standardly used. And that was the reason for our response. If we had responded that in isolated instances, we would probably have suggested that a very, very low percentage amount of the total cost of the defibrillator, because obviously it's going to be used primarily for other things, including the cardiac events. Okay. Regarding there was a question about the Delaware County. Is there a payment schedule that has been communicated? I think we answered that earlier on, and also correctly pointed out victim questions have increased this round, and it would be nice to provide more clarity regarding what they can either do to access or influence how funds are spent, other than simply letting them know we cannot provide legal advice. With all due respect, I think we have pointed out that these monies are being spent by the county, and that is the place to attend county meetings. Most counties have posted on their website when they are having meetings for this. The specific response, I believe, Morgan, that was being referred to is the gentleman that asked the question as to whether or not he had given up his individual rights to recovery or whether or not the state had given up his right to recover, and why couldn't he just get money directly? That to me was the legal question that we didn't feel we could refer to. If I were to answer it, I would have answered that no, the state didn't give up any rights for any individual, but that is why we said that giving legal advice like that is just something that they were going to have to see. We didn't mean to be particularly terse about that. Okay. I think that's a very good suggestion. I think we will make as part of the website, unless I hear any objection. We will set forth the way people can get input into it. I think it's a very good idea. Happy to do it. So with those explanations, could I have a motion that we adopt the recommendations of the Technical Advisory Committee and be able to respond to the people who ask the questions in a way that is set forth with all of the cautionary language that is on there? Could I have a motion to that effect?
Because I sit on the Technical Advisory Committee, I was hoping someone else would make the motion, but I'll
I'll
make
move.
it if there's not.
I'll move the motion. This is Commissioner Postal.
Thank
I
you.
could,
Thank
I
you.
lost the screen here for a moment, gentlemen. I'm sorry.
No problem. You feel comfortable in seconding the motion, Kevin?
Sure. Yes, I do. I'm sorry if you didn't hear me.
Okay, we have a motion and a second. Any questions? Further discussion? Favor, please say aye.
Aye.
Any opposed? Motion passes. Okay, that will take us on to the final agenda item, which will be that Commissioner Boozle had asked, he had attended a National Settlement Funds Conference. And so you know, there are various meetings, Dennis had alluded to it, various meetings that are going on concerning what other states are doing with the settlements, what procedures they're following, et cetera. I will say that at least the reports I get, and I will admit that people probably are going to be somewhat biased in reporting to me, but we get pretty good reviews for how we did it, both the makeup of the trust, the manner in which it was selected, the way that it was the Commonwealth, and the whole settlement is directed at getting as much funds into the counties as possible. And we also hear very positive things concerning how far along we are, that there are states that have not even begun to distribute the funds yet, let alone be at the point where they're now distributing it and have mechanisms in place for getting reports back on how the money is being spent. So that's the input I get, but I thought it would be worthwhile to let Kevin report on what he heard at the National Settlement Funds Conference. So Kevin, it's all yours.
Thank you, Tom. I just want, it'll be very brief, and I just wanted to thank you guys for all the work that you put in. This board has really put in a lot of time to get this information out to the counties and provide the best technical assistance that we can. I found that there's a group called OSLN, Opioid Settlement Leadership Network, which is comprised of all the states, and I had the pleasure of attending, and what I found was a lot of variance from state to state on how the settlement funds were A, distributed, and B, how they were using them. And the other part of that is the Exhibit E is recognized across each of them, although, and something that sort of caught my attention was a very similar sized county as to my own, and the amount that they got was less than 3% or 4% of what we received in our county with the similar population and size and issues. So, you know, what I would say is I like the fact that we do have the trust established. A lot of members of that group, the OSLN group, were very envious of how we were doing this, and I think that's a kudos to the AG's office and those that were establishing Exhibit E. So I do like the way it was distributed. I talked to some of my fellow commissioners upon return and expressed that with them, and they find that we have a better coordinated effort with working with our SCAs and our multiple county department heads, including our obviously our drug and alcohol, of course, but our jails, our aging, our CYS, and we have a very comprehensive approach at spending these dollars that I don't think that other counties and other states have enjoyed. So that's sort of my summary of what happened. Of course, I really like to listen to their programming, some of what they're doing, and what I would recommend is there's some information out on the NACO website about the OSLN and some of the projects and programs that are being developed. You know, I have no fear of going out and stealing someone else's idea as long as it's going to benefit our people and our residents. So I would encourage you to do that, and I'm encouraging our County Commissioners Association. We've talked a little bit about having a sort of a best practices surrounding, and I think between the reporting and the questions that we've received so far through the trust, I think we could put together a pretty good package of a program that would be very well received and attended, and perhaps through DDAP and some other programs we could do the same. So with that being said, I won't hold up anyone else's time, and I thank you very much for the opportunity to speak, Tom.
Thank you, Kevin. One piece of new business that I have is that we are required to annually, and that is being interpreted for this strange first period of time as being in 2024, to make a report to the Commonwealth Court. And we're required to make an annual report as to what the trust has been doing, how the money was distributed, to whom it was distributed, how it was spent, et cetera. Obviously, we do not have the information right now as to how it was spent, just given when the first payments were made. I have asked council in conjunction with CCAP, regardless, to prepare an annual report for 2023, which I would hope that would be ready in the reasonably near future to be filed sometime in October of 2023, which will detail everything that the trust has done from the time of its inception in July of 2023 through 2022 through at least the 1 year period ending with the beginning of the trust, and it may even extend to include the payments that information that we sent out on September the 1st. We will circulate that to the trustees before we make a filing with the Commonwealth Court, but it is aimed at staving off any question as to whether or not we were making annual reports to the Commonwealth Court pursuant to the order. It would be my intention that, and you listen to Dennis's time frame for when we would have all the information going forward in the future. We will probably be in a position to start compiling a very detailed report, particularly for next year as to how the money was initially spent. And even though we will be putting this on our website in order to make the report to the Commonwealth Court, we will be aiming for May 1st to May 15th of each year, including 2024, to make that annual report. I would expect the annual report in 2024 to be much more detailed than the one we will be filing in October or so of this year, and in fact will really cover all the information that we get as a result of the information requests that we are sending out to all the counties, and be able to give the court a very detailed explanation of how the counties have been spending the money that the monies that they received, and will include what all has been paid out, and at that time probably should also be able to include whatever the status is of wave 2, so we have a more cumulative figure of what is being spent out. So that is our intention. As I said, I will send out the report so that nobody is caught by surprise. Obviously, comments back would be greatly appreciated, but regardless of whether we get, it's not going to be a specific approval. I don't want to delay this thing to our next meeting in November. So we will be spending it out so nobody is caught by surprise and can make comment on it. Finally, I would note that we put on the agenda when the next meeting is November 30th, 2023. Please write that down. I would like to have full attendance at that meeting. And it should be one where everybody is there. We're going to have a lot of important steps to decide. Prior to that meeting, I will also be sending out a tentative meeting dates for 2024. Please get back on that. If there are dates that are just out of question, if I'm overlooking any important holiday, whatever, please get back to me, because I want to make sure, as much as possible, we should be striving to have perfect attendance at these meetings. We only have this year, at the conclusion of November 30th, we will had 5 meetings. I don't think it is asking too much for people to attend those meetings, and clearly ask any questions that they want to in between meeting times. And if something really important comes up, we can always call a special meeting. So, any other new business to come before the group? Have a motion the meeting be adjourned.
So move.
Okay, we have a motion and a second. All in favor?
Aye.
Thank you very
Aye.
much.